Welcome to Employment Law This Week. I'm George Whipple. Non-compete agreements are a tried and true way for employers to protect their trade secrets when employees leave to work for competitors. But right now, these agreements are under legislative attack on the state and federal level. This week, we look at an alternative tool to protect trade secrets, the inevitable disclosure doctrine, with the team from Spilling Secrets, Epstein, Becker, Green's podcast series about trade secrets and non-compete law. In this episode, they're joined by special guest Jimmy O, an Epstein, Becker, Green attorney who participated in the most famous trade secrets case of all time, PepsiCo versus Redmond and Quaker Oats. In that case, the Seventh Circuit applied the concept of inevitable disclosure of trade secrets to bar a senior executive from taking a job with a competitor. The court found that a former PepsiCo employee would inevitably disclose proprietary information in his new position with Jimmy O's client, Quaker Oats.
I remember running down to the Northern District of Illinois at 219 South Dearborn Street, walking down the hall to Judge Lindbergh's chambers and running into Jim Clark, the second chair to Roger Pascal in that case. He had just picked up the opinion, and I could tell from the look on his face that we had lost.
After the historic PepsiCo case, many predicted that the inevitable disclosure doctrine would be used to enjoin departing employees from taking a job with a competitor, even when there was no non-compete agreement in place. But in practice, PepsiCo has not really changed the landscape. Epstein, Becker, Green's Kate Rigby tells us more.
If you look at the cases across the country and the status of the law in each state, there are not many that, have outwardly embraced it. And when you do get a decision that is really taking into consideration whether the main reason is inevitable disclosure, it's usually some pretty similar fact patterns within those cases.
But Epstein, Becker, Green's Pete Steinmeyer says that the current climate for non-compete agreements could mean an uptick in inevitable disclosure cases.
If you can't use a traditional non-compete, what are you going to do? So I do think that if non-competes become more rare, I think we will likely see a lot more litigation around the inevitable disclosure doctrine.
And what was the secret to PepsiCo's success in that famous inevitable disclosure case? Jimmy knows firsthand.
PepsiCo altogether put a pretty compelling story and a pretty compelling mosaic of evidence of why, for all these various reasons, when you put them all together, there was a big threat to their business at that point in time. And so I think that word to the wise for anybody who is looking to put on an inevitable disclosure case or any trade secret case is to always think about what is the most compelling story as to why these trade secrets need to be protected now.
Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.